I'm conscious of the fact that some of the things that I'm going to say today will seem obvious to some of you, and you'll probably know better than me about some of the subjects I'm going to tackle. I've asked just to give an overview of the ways in which mental health interacts with the criminal justice process. So that's my intention. So we'll see if I manage to do that. The courts grapple daily with that interaction between the law and issues raised by mental health disorders. And these issues can relate to the substantive fairness of the conviction, or they can relate to the procedural fairness in the trial process. Expert evidence has come to play an enhanced role in criminal proceedings over the last few decades. The accused's mental health can have a bearing on the criminal trial in a number of ways. First, a mental disorder or abnormality of mind may have caused or materially contributed to the commission of the crime. Fairness and humanity dictate that the criminal law should take account of that. There are two statutory defences available. The first is that the accused lacked criminal responsibility because of the mental disorder. This replaced the common law plea of insanity. In 2010, the plea, if successful, technically results in an acquittal. But that acquittal in itself can result in an order for detention by the state and the imposition of compulsion and restriction orders, as the court thinks fit. It's because of that power in particular that practitioners, especially defense practitioners, have a very difficult choice to make, which is whether to introduce mental disorder at all into the proceedings, because experienced practitioners will know that introducing an element of mental disorder on the part of their client could potentially result in the client being detained indefinitely at the state hospital, as distinct from receiving what might be a relatively short determinate sentence. And it's a difficult decision for the defense to advise on. Whether the person is suffering from a mental disorder is not intended to produce any form of extended argument at trial, and so the definition in the Mental Health Care and Treatment Act of 2003 applies. Following the Carstairs inquiry in the mid-70s, which I attended, psychopathic personality disorder is, of course, excluded on the basis that the nature of psychopathy involves that person knowing or appreciating what he or she is doing. The second defense, which is available, in other words, one that does not amount to what was formerly known as insanity, does not involve a complete defense to the charge. So where a person would otherwise be convicted of murder, a conviction for culpable homicide can be substituted on the grounds of diminished responsibility. Why do we have diminished responsibility as a concept, which applies only in homicide cases? Because it was a way of effectively circumventing the death penalty. That's its historical origins. The test for diminished responsibility was set out by the High Court in the case of Galbraith, although it was put in statutory form in 2010. Galbraith was a controversial decision at the time for a relatively simple reason. The issue in Galbraith, and you may recall that Galbraith was a case in which the wife of, I think, a police officer was said to have suffered from battered wife syndrome, as it was known, and the question was whether that provided a defense of diminished responsibility when she shot her husband while he was asleep. The problem with Galbraith, as I see it, and there are several problems with it, but the main one was that the issue was never allowed to go to the jury. It proceeded ultimately on a concession by the Crown that culpable homicide was the appropriate verdict in that case. Some of the principles in Galbraith, I feel sure, will be reviewed over time, although not by me or the Lord Justice Clerk, because we're retiring in February. The broad principle which is to be applied to determine whether someone is suffering from diminished responsibility is, of course, whether they had an abnormality of mind at the time of the offence which substantially impaired their ability to determine or control their conduct. In other words, as it is put more colloquially, whether there was something far wrong with the accused. Now, as I say, diminished responsibility only applies in homicide cases. It does not apply in any other type of case. So in that sense, it's more like a plea of mitigation rather than a defence, because it concerns the degree of blameworthiness of the individual. And that's in contrast with a mental disorder applying as a complete defence. Galbraith also led to a shift in the role of the expert. The court, in particular Lord Justice General Roger, whose father, interestingly, was a psychiatrist, stated that abnormality relied upon what must be determined by, and I quote, the appropriate science. In light of that, it's difficult to see how diminished responsibility can now ever be run successfully without the leading of psychiatric or, interestingly enough, psychological evidence. And that was a change from the past times when the jury were entitled to find diminished responsibility established without hearing expert evidence. And I return to what I said earlier, it's a means of avoiding the death penalty. Whether the accused's responsibility was diminished at the time is ultimately a question for the jury, and an expert technically should not actually express an opinion on whether diminished responsibility was established at the time, but confine his or her evidence to whether the accused was suffering from an abnormality and what its effects might have been. Now, as our understanding of mental health becomes more sophisticated, and I think it is becoming more sophisticated, a degree of medicalization, if that's a word, of legal tests is inevitable. For example, the general position at common law is that evidence of voluntary intoxication cannot be used as an excuse for the commission of a crime, even where the level of intoxication is resulted in an absence of relevant intention. A more enlightened approach is taken in the statute, which provides that while intoxication is not an abnormality for the purposes of diminished responsibility, it does not prevent a separate abnormality being established. In other words, the intoxication can run in parallel with an abnormality. In those cases, expert evidence is going to be particularly important. And interestingly, in an era in which we better understand the nature of addiction, the court may need to look more closely at whether intoxication is, or the intoxication was truly voluntary. The second point at which mental health may arise is that in the trial process, if the accused is suffering from a mental condition such that he is incapable of effectively participating in the trial process. And if that happens, he will be deemed unfit for trial. Now, this is usually determined pre-trial at the stage of the preliminary hearing, and it requires the judge to determine the accused's fitness on a balance of probability and on the basis of the evidence of two doctors. The concern here is the person's current mental state rather than the state at the time of the alleged offence. Fitness for trial is then not a defence to the charge libelled, but is a plea in bar of the trial taking place at all. And that is the reasoning there is that the fairness of any trial would be substantially impaired if the accused cannot understand the nature of the proceedings. The judge or the court can raise the question of fitness for trial itself, and similarly it can order an assessment or make a treatment order. And these can allow for detention, for assessment and treatment of a person with a mental disorder. The court can do that at any time between the first court appearance after arrest up until the final sentence is passed. It's important that judges, even in the absence of the submission of a party, consider any medical information which is available at the time, and that they should stay alive to issues of mental health throughout the proceedings. The third and most common point at which the issue of an accused's mental health arises, and which will be of more interest, I think, to the conference today, is in disposal and sentencing. Now, I know that Lord Beckett is going to go into the sentencing process in detail later, but by way of an overview, it suffices to say that the sentencing process guidelines developed by the Council require the sentencing judge to consider all relevant circumstances, including those of the offender. And that includes, amongst other matters, the offender's mental health, and in particular, whether that mental health is related to the commission of the offence. Any expert evidence led in relation to a successful plea of diminished responsibility may therefore be relevant again at the point of sentencing. If a finding of unfitness for trial is made, the court will order an examination of fact. Now, that is the process which the accused does not have to attend, and at which the judge alone will determine whether it has been proved beyond reasonable doubt that the person committed the offence charged. I say that not in relation to whether he would be guilty of a criminal offence, but simply whether he did what is libelled. And if the court thinks that he did do that, then there is a flexible set of disposals available, and these are the same, essentially, as those available where the accused has been acquitted on grounds of mental disorder. They have to be tailored to meet the accused's particular circumstances and address the risk which he poses. The most common of these is a compulsion order, or a compulsion order with restrictions necessary to protect the public from harm. These are not to be regarded as punitive, not to be regarded as punishment. They are designed to protect the individual as well as the public. And again, the medical experts have a role to play in that, as the court must consider medical evidence before it makes such an order. The last thing I'm going to talk about is the importance of the mental health tribunal in the criminal justice process. And again, I know that Laura will be talking about this in due course. Once a person with a mental disorder has been through the criminal process, it is likely that he will probably become the subject of the mental health tribunal's jurisdiction. If, for example, he's been made subject to a compulsion order or one with restrictions, that order is going to be subject to review, extension, and revocation procedures under the Mental Health Care and Treatment Act of 2003. As an interdisciplinary and specialist tribunal, the MHT is best placed to make ongoing decisions about the individual's care and any risk he poses to the public. The tribunal's decisions concerning ongoing detention or conditions attaching to that detention can be appealed to the court. However, in determining any appeal, the court has regard to the tribunal's expert knowledge and in essence the court will be slow to interfere with any decision or matter falling within the tribunal's expertise. In that respect, the court respects the tribunal's function and its position within the justice system. It is important that law and the courts do not maintain or foster outdated notions of or stigma attaching to mental illness. It is equally important that an accused with a mental disorder is treated with care whilst going through the court process. Trauma-informed practices may require to come into play. The courts rely upon these who, like yourselves, are in the mental health and medical sectors to keep them abreast of relevant developments in their field. It is appreciated that the courts tend to lag behind the medical and mental health definitions and concepts, and they are always in the process of trying to catch up with new developments. Because not only does new, pertinent and peer-reviewed research have the potential to affect the outcome in an individual case, but also, if our understanding of a particular medical area changes, it can affect wider questions of legal policy. We've seen this already in the context of the sentencing of young offenders, and in particular the guideline which has been introduced in that regard. Because these principles will have to be looked at carefully and developed by the Council, I am particularly grateful that they have put together this interdisciplinary event, and we all, I'm sure, will have much to learn from each other.